Accounting is strictly regulatory and investor related. And this is why, I warn people by strictly trying to use accounting as a legal defense. Because when you use accounting as a legal defense without understanding its true functions and how it's measured and its mechanisms, you will run into major issues when trying to assert your accounting defense. As a matter of fact, an accounting should never be used as a legal defense. And when we get to the court section of Set U, you're going to understand why all this is going to tie together. You will understand why I'm saying do not use accounting as a legal defense.
Have to understand how they see it, how they operate. Once we understand how they operate, you'll realize that in many cases, the debt that they're already trying to collect from you is a debt that they already. A lot of the balances, look at your contracts, they remain in balance. It's never what's actually booked. You ever looked on TILA, page 2 of your contract? You ever notice that the itemization, that number is always low, and then when you get to the finance charge, it's always a bigger number? Isn't the finance charge supposed to be disclosed? The items of the finance charge supposed to be disclosed on TILA? But it's on page 2 or whatever the page, your itemization. It's always some amounts paid to others on your behalf. It's always a low number. But then you look back at your finance charge, when you subtract that low number from the finance charge, you be like, well, where the rest of this money at?
Break it off another hot explosive mix.
They studying the stars now. Supreme Elite.
You're rocking with the best.
Came on reading numbers, they were reading memes. He was reading fire, planning out the dream. Turn every late fee in the case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress.
You're rocking with the
How you
best.
turn the loss in the last check.
Gotcha, bitch.
Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print.
You're rocking with the DJ that keeps the hits coming.
He designed the way we move our 2 cents. Whipping up, he got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, they can't claim. You look like you wanna let go straight. I thought so, okay. I'm back in this symphony, stuck on the band. What's up?
We're about to take it back.
Gotcha, bitch.
You're rocking with the best.
Put a 30 to the semi and shoot it. Put a stand on the Glock and just use it. It's gonna be a headshot, we aim at your medulla. I got all my jewelry on, so I ain't tryna be a brawler. So we gon' shoot like a hooper. Hop in the car, put it in turbo mode.
You're rocking with the DJ that keeps the hits coming.
I might just kill the club. Hop in the car, put it in turbo mode. I might do 200, I might do the whole dash. I might just crash it with, I ain't have to pay for it. I might just kill the club. Put it in turbo mode, I might do 200, I might do the whole dash, I might just crash it with, might have to pay for it, I might just kill the club. Hop in the car, put it in turbo mode, I might do 200, I might do the whole dash, I might just crash it with, might have to pay for it, I might just kill the club. I'm on the stage, I'm lit, it's turned up. They see my ice, I'm lit, I do it all the time, all my life on the line. Shawty be acting real shy, she wanna show me, yeah, she wanna slide. Hop in the back of the ride, they look in my eyes, it's demon time. Like, do you wanna ride with me?
Gotcha, bitch.
Are you down to die for me? Are you down to die for me? Do you wanna ride with me? Shawty, you mine.
You're rocking with the best.
Gotcha, bitch.
Come for a ride. Hop in the back of the ride. Hop in the girl, you dead. Girl, you thick. Is you from the deep? She ain't got a man. Baby, you can leave. Damn. Baby, you can leave. Damn. Girl, you dead. Girl, you thick. Is you from the deep? She ain't got a man. Baby, you can leave. Damn. Baby, you can leave. Damn. Girl, you dead. Girl, you thick.
hip hop. You will rock with the supremely teen universe.
The attorney for credit acceptance with the case, the lawsuit, I called him up after we settled, just to let him know when I got the title, and I've been texting him because I'm trying to get him to be a part of the professional team. I actually have like real live professionals in these fields that got extensive years of professional that I'm in cahoots with. Mr. Gamble, how you doing, sir? Hey, nice talking to you. I just wanted to let you know personally, I appreciate your help. The matter of resolving this with credit acceptance. I did receive the title. Just want to give you a thank you, man. I appreciate your hard work, man.
I'm glad we're able to work it out.
Yes,
and, you were a big part of the process too. So.
Yeah.
I never heard of that. It seems like from the orders that I've seen, it's still called a note that's not supposed to be bifurcated from the deed. It's still called those things.
There you go, right there, bro. We're on two different levels, bro. I'm gonna tell you that right now.
But if I was to get into the mindset of criminals,
because you came up here like lightweight trying to check me on my credentials, and you don't even know it from a professional level. See, this is the difference between me and you. This is the difference between me and you. I know things you don't even know exist.
I'm answering with procedural language instead of the banker's language that I spoke about earlier.
Internally, if you live in that world, you know all of them do it. This is the difference.
If I was to speak on...
Let me tell you this, hold on. I'll let you get the mic back. This is the difference in how you will argue and the way I will argue. Because the name, what they do, the new name it takes on, the new ways they move around, that all plays a role in a consumer claim. Knowing the game from their field. And this is why I really don't like doing these things, because everybody I come across, they act like they know it all, but when it gets to the top level, professional level, they have no clue of that realm. I operate from that realm. I don't operate from TikTok consumer level consumer claims. I operate from a corporate professional realm, bro. In real life. Real life. Real life. So, respectfully, bro, there's nothing more for me and you to talk about. You don't even know that answer. I really don't even want to talk to you about anything else anymore. I'm G-check me and you don't know what I know. Don't try to G-check me. You're supposed to know the answer. According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
You're rocking with the best. You're rocking with the best. You're rocking with the best.
He'll be my salvation. When you feel lost, they scrapped all your docks, and you haven't got that estate. And they took your car, or they took your house. You always know we will save you. Because if you really understand, we're on a professional level.
You're rocking with the best.
If you don't know, then you better know. We're on a different level. Because
You're rocking with the best.
Oh, honey. Oh, honey. Back with another banger. They call this another banger. And y'all, before I get started, please. Oh shit, please. Shout out to those that, you know, hit me in the messages, hit me in the inbox. Got off the phone with someone, good brother, good decent brother for what I can tell from what I've seen so far. And he kind of gave me a rundown of all these gurus' names. He has their processes, he has their classes, and he's going to share them with me because I'm going to need a good laugh tonight before I go to sleep. But for other people, let me explain something to you. When you talk to me or text me, I want you to understand, I'm not looking at your situation the way you're looking at your situation. I'm not looking at your claims the way you're looking at your claims. I don't care if you say anything to the judge that had the judge like, I don't care. I don't care if you say, oh, they said this and they couldn't respond back. I don't care. I don't care. None of that matters to me. I'm not looking at it, well, they couldn't do this, they couldn't do this. And at the end of the day, if they are still filing or moving for summary judgment, I don't care what response you're looking at to tell you, to give you the inclination that you're on the right track or you got them. I don't care what verbal response you get, what in-court response you get. I'm looking at the situation from a legal standard. Listen, you are not going to win on a default. Courts settle cases on its merits. I don't care if they made an appearance 60 days late. The courts are going to let them enter and make an appearance as long as they can show good cause. And in a lot of cases, judges are going to set aside the judgment if it's made or let them enter the case. The same way, if you show good cause, the judge is going to set aside your default judgment and they're going to reopen the case. Trying to fight that battle, once again, that lets me know there's a problem here with a person's understanding of court. If you feel like the judge keeps giving them chances, once again, you don't understand court. And I don't care how solid your arguments may think they are. When I put them under the judicial light, when I put that judicial light up under them, I always find errors. I always find holes. Wanna know why? Because most people, when they want to share documents with each other, they're sharing documents for a confirmation bias. Oh, this looks good. Oh, you got him. No. When I look at your documents, I'm looking for holes in your arguments. I'm looking for rebuttals. I'm looking for structure. I'm looking for your foundation. I'm looking for what strategy are you using. I'm looking for everything the opposing attorney would look for when they're responding to your motions. Why would I be doing that? Because by me doing that, it's in your best interest. It serves you and me no good to be like, oh, you got him. Yeah. When I know, in fact, that you made a weak argument. And if you don't want my opinion, don't ask. Because I'm rarely ever going to tell you anything that you want to hear. I'm going to tell you everything that you need to hear. So, I'm glad, and I will give a shout out to everybody who's now starting to take court serious because of me. Shout out for the emails. Shout out for people just, hey, can you check this out? Cool. At least I'm getting the conversation started and people at least want to seek some form of a higher counsel before they just start filing these blind documents, which are 9 times out of 10 dead on arrival. See, with me, at least you're going to start thinking before you act. Or you're going to start thinking, because let's run down the checklist in the past week. Let's run down the checklist. From a legal standard, court, I've validated the wet ink signature. I've validated the vapor money theory. I've validated the show me the note. I validate citizens or pro se litigants citing Title 18 USC in their documents. I haven't validated the secret trust fund account. I haven't validated what? These technicality wins. When you're winning off a technicality on their own motion to withdraw the case without prejudice, meaning they could bring it back up. And people were on other apps calling that a win. I say, no, it's not a win. You don't win anything unless it's finally settled on the merits, whether you win at trial or you enter into a settlement as the plaintiff on your merits. The new culture empire, whether you want to believe it or not, whether you want to accept it or not, whether you want to fight it or not, the new culture empire is the most ever evolving, trend setter, bar raising standard in these spaces. We are the standard. The New Culture Empire Supreme Elite Team, we are the standard when it comes to pro se litigation. We are the standard. Because, once again, I read over 10 different people's briefs this week for free. Normally, you got to pay me for that. But I waived them all. I said, you know what? Let me waive it. Let me just read it. Let me try to understand. Let me see where they're coming from. And I find it very ironic how all 10 briefs that I read, everyone's argument is identical. Now, a couple were very decent, but once again, what is missing out of all these 10 briefs? You know what's missing? Understanding of courtroom nuances, understanding of the rules and procedure. Let me get on my bullhorn. Let me get on my soapbox. Court is not about what you believe the facts in the cause of action or the elements of your case. Court is about rules and procedure. You guys are still spewing out the facts and elements of your case. You don't have case law to back it up. It's not supported by law and fact, and your claims are not in accordance with the rules and procedure to the point where it can withstand a 12B6 motion or a motion for summary judgment. The mere fact that the other parties are still moving for summary judgment means that you have not stated a claim upon which relief can be granted. I don't care how good you think your motion is. Because you got your motion, then you got the legal standards that's going to be applied to your motion. So for a few of you, I think you need to go down this process. I think you need to go down that road. I think you need to suffer your first defeat. Oh, yeah. I think from what I've seen, none of you are going to win your case. I'm just going to say it straight up. None of you are going to win, but that's not the bad thing. Because wins and losses, once again, are all part of the same coin in court. You don't get to your wins instead until you go through your L's. You are going to lose in court before you start winning. Oh, yeah, you're going to lose. Want to know why? Because no one can prepare you for the nuances of court. You get prepared for that through experience. So once, whatever your learning capability is, whatever your learning capacity is, that's however you make that next step. Every individual is different. But I will caution you all, because a lot of what I'm seeing in your motions as well, y'all pleadings that I've read over this past week, I see a lot of emotionally attachment to them. I feel like you guys are arguing it from they did me wrong. I'm frustrated by what they did. And you're not really focused on painting a beautiful canvas for the judge can look at your claims and say, you know what, on its face, this may be plausible that they did this. Hold on. Y'all gonna have to respond to this, because when you're dealing with court, though the finance company's lawyers, they know court rules and procedure. They don't attempt a motion for summary judgment just for the sake of doing it. They never do that. They're not going to move for summary judgment unless your claims are not in line with the rules and procedure. Let me give you a little inside trade too. Y'all, if you don't understand court rules and procedure, the merits of your claims don't even matter. And we're going to get into that. The merits of your claims do not matter. They don't matter. Stop leading with your facts and what you think happened if they're not in line with the court rules. And this is something that you social media gurus don't understand. This is what you social media gurus have no clue of. Y'all don't know court rules and procedure. Y'all don't even, I ain't talking about the students right now. Y'all move to the side. Let me bring y'all teachers to the front of the congregation. Okay, so gurus, why are y'all consistently telling people to raise accounting in court? Because that's what we're going to get into today. We're going to get into what we went over in class 3 of the Supreme Elite Team University, which shout out to the Columbia Business Law School and Mr. Steven and them, who sits on the board of directors of accounting at the Business Law School. Shout out for y'all amazing investigation and y'all amazing paper that served as the focal point of class 3. Shout out to that Business Law School, and shout out to the contributors that sit on the American Accounting Association. Shout out to y'all.
You're rocking with the best.
I got to shout out William and Mary School of Law. I got to shout out all the universities whose papers contributed. Shout out to the faculty. And shout out to the American Accounting Association and the board of directors. Shout out to the ISAB. Shout out to the FFIEC. Shout out to all the top elite professionals who were so kind enough to put their professional opinions out there, and we just, the Supreme Elite Team, we just soaked it up. We were a sponge. Shout out to the SEC attorney. He's been very instrumental. Shout out to the homie T-Dot with the connections. Shout out to the Fannie Mae, Freddie Mac IT worker. Shout out to you. That was a beautiful phone call. Shout out to the ex-Deloitte and Federal Reserve chair who took the time to even read one of my documents. Shout out to T-Dot with that connection. Shout out to you, man. May you have another blessed 80 years. I've learned a lot from you, and I haven't even met you face to face, man. Shout out to you. Now, why do we think that we know it all? Now, let's explore that. I'm going to assume that everybody here is not a licensed attorney and never worked at ComputerShare or behind the scenes or dealt with investor relations or never had to put together a balance sheet or never had to put together the trust documents for the securitization trust. I'm going to assume that none of us never worked in our field, never worked behind the scenes, never sat on a board meeting, never got on a conference call with investors. I'm going to assume that even myself. Okay. So without that experience, because that's actually one of the most important parts to understand in securitization, but whatever. How can a teacher say they know about securitization, but that element of the understanding that you need to have is 100% missing? Now, if that is missing, you got two options. You either go to school, get the qualifications, and then work at these positions and get on the job training, or you connect yourself with people that live in that world and you can use their expertise. You connect yourself with attorneys that's been in court 1,000,001 times. Nah, that's too much like right. I think they want you to stay away from lawyers, stay away from the corporate system, stay away from the corporate world. Nah, stay down in the consumer FDCPA claims. But nevertheless, if you do not understand a phrase that I've coined, hear anybody else say it, and it is 333 Wednesday, March 4th. 333. Y'all heard me first. Come up with this. I coined this. The 5 lenses of a contract. The 5 lenses, Lens, Lens, of a consumer contract. If you don't understand the 5 lenses, you don't even understand consumer contracts. Because TILA, I'm going to say it again. TILA is 98% a crock of BS. I said this earlier when I was on TikTok earlier. TILA, what does TILA really deal with? Oh, you got to disclose the APR. Oh, you got to disclose the finance charge. Oh, you got to disclose how much they got to pay. Well, when I look at TILA, I look at it like, well, hold on. TILA, you're not really addressing the core elements of securitization. Because pretty much TILA is pretty much validating things that never took place or things that are not true. But as long as they tell you what the APR is, tell you what the finance charge is, every single consumer contract violates TILA. Oh, God damn it. We getting into it now. Every single consumer contract violates TILA. How would I know that every single consumer contract violates TILA in some shape, form, or fashion? Where I tell you, I wouldn't know if I was looking at the contract through the lens of a consumer. When I look at the contract through the lens of corporate financing, I realize that the contract always says one thing, but what's going on is a totally different thing. The contract is always going to say, here's your gap protection, what business taxes, what else they got on there? Your service contract, what else they got on there? Your wax on, wax off fee, has your processing fee, has all these fees, finance charge. But the actual finance charge is never listed on TILA. But they got TILA for you. Your actual finance charge is never even listed on TILA. And this book brings us to accounting. Many people actually think that these finance companies are following the accounting guidelines. And since they can look up at ASC, they think that they know how accounting goes. When in reality, all the accounting that takes place is internally. So how would you know what they're doing from an accounting standpoint if you don't even understand how they view the contract from a corporate finance level? If you only understand the contract from a consumer level, you will never understand accounting. Just because you can go online and cite some stuff and research some stuff, how do you know from an internal accounting standpoint that's exactly what your finance company is doing? How do you know what to look for? What language do you look for? What terms do you look for? Do you actually understand the words that they're using? Do you understand a balance sheet? What does a balance sheet even mean? A financial statement, what does it mean? When do they net the accounts? When are they supposed to match the principles? When is it appropriate to use this measure of accounting? When is it inappropriate to do it? And are they following all the principles when they're measuring and reporting these on their financial statements? How are they classifying the revenue? Are they classifying it correctly, or they're incorrectly classifying it, leading to less taxes being paid, but they're misrepresenting the quality of the assets from the underlying performance of the contract? How do you know what disclosures are they even supposed to make to the investors? How does the regulatory agency view these contracts? Now, how does the court view the contract? So how can you take investors, regulatory, corporate finance, and infuse that into your consumer claim without violating the strict rules of court? Accounting is not a legal defense in getting out of a debt. You cannot say, oh, they did this on the accounting, so I don't owe anymore. So let's just strip that away. Let's strip accounting as a legal defense and let's move it right on out the way. What else are you bringing up accounting for? What else are you bringing accounting up for if you cannot use it as a legal defense? If you can't use it as a legal defense, why are you bringing up accounting? Because the courts have consistently said inaccuracies with the accounting or violation of the accountings is for the regulatory agencies to get on them about. That's the Federal Reserve, that's the SEC. So let's move that out the way. Oh, securitization. That's another one. You're not a party to the agreement. You're not a party to the trust documents. You're not an investor. You didn't put up the money for your own loan. You went to them to get the money. The investors put the money up. No. Your signature did not create the credit again. We ain't gonna go down this road again. Don't start that. Don't start it. You did it. Because if you knew if your signature created the credit, you wouldn't need the finance company anywhere. You'll just go crediting yourself all over the world. So securitization, you're not a party to. Accounting is for financial reporting. It has nothing to do with a legal defense in court. So accounting and securitization, bam, on its face, those are the two things that you cannot use as your legal causes of action. Now you got to start asking yourself again, why am I raising these arguments? And if we're honest with ourselves, we are not approaching this from a corporate attorney, corporate finance company, sophisticated investor, or the regulatory oversight agencies. We are looking at it as a consumer. And what is the number one things that consumers want to do? Consumers want to get out of the debt. So everything that they're doing in court is from a consumer's lens. If that is your mindset, you do not have a clue what's going on in this system. And just to be frank with you, I don't blame you. I mean, you can only do what you know. If you didn't understand that the 5 lenses of a contract actually exist, that the contract is looked at in 5 different multiple ways, then if you did not know that, and I'm not saying, oh, I know it, I'm talking about through your actions. If you did not know that, then this is more the reason.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
Now, you don't learn all that in one day. As a matter of fact, I will tell you this. This is a highly complex system. And yes, a lot of this stuff is hidden in plain sight. A lot of these things are hidden in plain sight. A lot of these things are a search engine away. But if you don't understand to know what to put, like this is what I mean. And this is what the set you brings. Class 3 was a masterpiece. Class 3 was a masterpiece. After this, Class 3 of Set U University will be dropping in the group. It will be dropping. It was a masterpiece. It was a brilliant dictation and breakdown of it. From 5 different levels, no, 4 out of the 5 different levels. Because how do we infuse all this in court? That's going to be the last leg, and that's going to be totally dedicated to court. Because once again, when you're bringing these claims, you're raising the standards and the requirements that has to be met. And since you're raising them as a consumer, there is a specific strategy that you have to use to even open the door for you to bring these claims. Notice all these claims, securitization, accounting from the investor, right? Trust me, I've been there, done that. And the judge did not dismiss it. But I see a lot of people trying to do that out there today, and the judge is dismissing it. Because I don't think like a consumer. I don't. We all may be one, but I don't think like a consumer. I think like them. Now, before we was given the term consumer, we were considered consumers of corporate debt. And then we were consumers of debt. And we're now just consumers. The sole function of a consumer in this world is to take on their debt at a high enough interest where they can repay back their obligations and make a profit. So can we stop conspiracy theories like they just picked your name out of a hat? Now they're trying to harass you. They don't give 2 good goddams about you or me. It is totally business to them. It's 100% business. Now, let me show you, before I get into what I really want to do, let me show you how they think about consumers when you come under the FDCPA. This is what they think about you. FDCPA, like, and here's another thing. Here's another thing. Here's another thing that I want y'all to understand. Only consumers pursue consumer claims. Only consumers pursue 100% consumer claims. Let that sink in. Now, this was a case from, I'll get the name in a second. Standard of Review, FDCPA Journaling. Y'all, for my FDCPA claims people, you about to see how they really think about you. And when I read this, when I first read it, I said, I will never give them the satisfaction of putting me in this box. I mean, about it. Investors and corporations, they settle for millions. They settle with the SEC for millions. They settle with the CFPB for millions. What did they settle with consumers for? What's the statute? What, $1,000 per crime? What you get, like $1,000, $1,500, what, $2,500 at best? In the same violations, they'll settle with millions for their investors, but they'll settle with you for $1,000, and everybody jumps on that money statute. Well, I can get money out of it. You get $1,000 out of it and get your $1,200 debt wiped away. Congratulations, you have cracked the code. Congratulations. Whoop-de-doo. Now, let's get into this in real time. And I hope, and we are over here at the New Culture Empire, Daniel Haney versus Portfolio Recovery Associates. Y'all know one thing about me, I always like to lead with this. If you don't like the way I'm saying it, then I will let the judge tell you. Because all I'm doing is bringing to the average everyday person the other sides of the coins. Y'all have been stuck in one side of the coin for so long that I'm going to bring y'all sides of the coins. Sides of the coins that whoever your teachers were or whatever's floating around online, they don't even know exists. So, TikTok, if you can you come over to the New Culture Empire? Stomping ground. I've been giving attention to TikTok lately, but give y'all seconds to share this live, and I will give TikTok 30 seconds to come over here at the New Culture Empire. Let's parlay over here in 1 second. And it looks like we're having technical difficulties.
Supreme Elite Team. New Culture Empire.
Difficulties, y'all.
Turn the lights on. Yeah.
Time is lit.
Let me fix this stream. All right, there we go. TikTok. New Culture Empire. anybody is looking to buy my Benz truck, 20 racks, you can have it. No liens, you'll be the owner of it. No liens. I have title. I can sign it over to you. You might have to pay the transfer fee, or I'll cover that. You're looking to buy it. As long as the money's all good, you can have it. I'll go through my lawyer, make a deposit, and you can either come up here and get it directly from me. I'll have the title. You can have it. So says they tell people to bring up the counter, but don't know the details to it, and then say, well, let them figure, audit the accounting. It's their job. Oh my gosh. I know they're not saying that. I know they are not saying that. Do not tell me they're telling, okay, so you bring up the accounting, and then just because you don't know what you're really doing, you want the other side to figure it out for them because it's their job. So audit the account and give me what I don't really know what I should be looking for. Like, give me what I don't give me. Like, I don't know. I just know it's accounting. And I've seen people cite this stuff. So can you give me what I'm really looking for, even though I don't know how to communicate it from a professional level to really understand? Hold on. If I understand, then why am I asking you to give it to me? I should already know what's going on. So shouldn't it read more like, this is what it is? This, and I'll be able to prove this by preponderance of evidence in court, or produce the accounting. Oh my God. That's what I told you. All of a sudden, everybody wants to be an accountant now. I didn't hear him talk about accounting 2 years ago. I didn't hear him talk about accounting last week. I didn't hear about it. I've been very consistent on the accounting for a minute. Everybody else is on negotiable instruments and filing fraudulent returns and stuff. I told you, I am the trendsetter. Whatever I do, people follow. The gurus. So, we review a motion for summary judgment on the pleadings de novo, meaning they're looking at it for plain error. We accept as true all facts pleaded by the non-moving party and grant all reasonable inferences from the pleadings in favor of the non-moving party. United States versus any and all radio station transmission equipment, 8th Circuit. We review a 12C motion under the standard that governs Rule 12B6 motions. Pursuant to Rule 12B6, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face, quoting the Supreme Court of Ashcraft versus Iqbal and Bell Atlantic versus Twombly. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. See, this right here. This is what the court is doing. The court is applying the legal standards to the claims. Most people think the court sees their claims from the lens of the person who made the claim, not knowing you raise your claim. Now the judge is going to look at your claim like this to check for sufficiency. That he's passing all the court rules of procedure. And that's the disconnect. People put so much into, oh, this will happen, versus, okay, how do I communicate this in a motion where it's passing the court sufficiency test? See, many people will always disregard things that they don't understand. They will always try to take shortcuts on things they don't understand, because most people are in so much of a bind, they really know that it's going to be hard for them to really figure it out. in the time that they really need to figure it out. So what do? Instead of just whatever doing what they got to do, they will try to get around it. But you're not going to get around the court rules and the court procedures because they govern the courts. They govern everything that happens in court. But no, continue to not read them or only want to read them right when you're about to start putting your complaints together. Yeah, you'll memorize it all in a week. Of course you will. You'll know how to argue your motion in court. No. I'm not talking about reading your motion into the record. The judge already read it. Now you have to argue it. No. That doesn't mean read it all over again. It means make your argument out of what you wrote. Hey, what Steve Urkel used to say? But anyways, you FDCPA people, we're going to see how they really think about you. Of course, they think highly of you. The FDCPA was passed to eliminate abusive debt collection practices. Now, what is one of the key elements about, what is one of the key elements about abusive debt collection practices? What is one of the key elements? Oh, I'm sorry, y'all. It's right here. What is one of the key elements of abusive debt collection practices? What is a word that sticks out to you? Yes. All right, here you go. Yes. What's one of the elements? Yes, they're collecting the debt. That means they're collecting the debt. That means you are the defendant. That means you're not the plaintiff. That means you're not assertive. That means you waited for them to pull the strings. Now, in this case, this guy filed the lawsuit in the course of the other party collecting the debt. Haney then filed the current complaint alleging FDCPA violations in 4 counts. I told you, the Supreme League Team University, we don't even worry about those. Count 1 alleged PRA violated 15 USC 1692E in several respects by misrepresenting the character or the amount of the debt being sought. First, count 1 alleged PRA suit on the Walmart account misrepresented as principal a sum that also included interest. Count 1 also alleged PRA misrepresented the amount it sought by demanding prejudgment interest on a sum that already included contractual interest. Regarding the HSBC account, count 1 alleged PRA misrepresented the amount it sought by mischaracterizing as principal amount that included interest. Finally, count 1 alleged PRA violated 1692E by alleging without providing proof of a valid assignment from HSBC of the HSBC card debt. Count 2 alleged Gamici violated same statute in 2 respects by misrepresenting the character and amount of the debt. And first, count 2 alleged Gamici's letters failed to identify which debts were being pursued, making it impossible to ascertain which debt Gamici was attempting to collect and making it impossible to ascertain the validity of the debts. Let's sit back and ask ourselves a realistic question. The person that filed this lawsuit, do you think he already knows the debts they're talking about? The person that's filing this lawsuit, do you think he already knows the debts that they're talking about? Like, do you think that they just sent him a debt collection letter out the blue and he has no clue about this debt? Do you think he has no clues? Like, somebody opened the account in his name, he has no idea? Of course not. They all know what's going on. Count 3 alleged PRA violated 15 USC 1692 F1 in 2 respects by using unfair or unconscionable means to attempt to collect the HSBC debt. Supreme Elite Team University. What do we teach in the Supreme Elite Team group? Do we teach to be passive, submissive debtors and just file a FDCPA suit as the defendant when they're trying to collect, or we get assertive and we get aggressive? Now, respect to this person because he did file the suit. He was the plaintiff. Respect. But I want to start seeing people be the plaintiffs outside of an FDCPA claim. Like, it's like that's the only time they're comfortable being a plaintiff, FDCPA. How about, never mind. Whatever. First, count 3 alleged PRA sought interest, fees, and other amounts not permitted at law or expressly permitted by the written instrument creating the debt. Second, count 3 alleged PRA sought interest on interest, which such compound interest was not expressly permitted by the written instrument. The defendants moved jointly for dismissal pursuant to Federal Rules of Civil Procedure 6. Haney resisted and the district court granted the motion. The first court determined that the prayers for relief in the concluding paragraphs of a civil complaint were not communications to the debtor or actionable collection efforts pursuant to the FDCPA. Rather, the court characterized them as mere requests to the court. Remember, strategy, how you word things in court. In the alternative, the court held that the original creditor's act of charging off the card balance did not preclude a subsequent assignee from seeking statutory interest dating from the time of the charge-off. Uh-oh, Houston, we have a major problem. What do we hear all the time? They charged off the debt. You don't owe the debt anymore. Right. See, just because we are so advanced in the accounting, we know that charge off has nothing to do with the consumer contract. Remember, this is the corporate finance lens we looking through it. It has nothing to do with the consumer contract. Charge off over here has nothing to do over here. Now, let's get to standard of review, my favorite part in any court. Reading the case. Now, we read that first part already. The FDCPA was passed to eliminate abusive collection practices. It broadly prohibits a debt collector from making a false, deceptive, or misleading representation or means in connection with the collection of any debt, quoting 15 USC 1692E, and from using unfair or unconscionable means to collect or attempt to collect any debt, quoting section 1692F. But look at this statute here. This statute is designed to keep you in the mindset of a debtor and a consumer, where you don't assert, you only go after them for violating the statute when collecting a debt against you. See, violating the statute when collecting a debt against you. They never want you to go after them based on the transaction as a whole. It's limited to them collecting a debt, and people get stuck in this consumer box. When evaluating whether a communication is false, deceptive, or misleading, we consider the perspective of an unsophisticated consumer. Hold on. When evaluating whether a communication is false, deceptive, or misleading, we consider the perspective of an unsophisticated consumer. This is what they think about you. This is what you're reaffirming in your Fair Debt Collection Act claims. Look at it. This is what you're reaffirming when you bring these claims. Look at it. Look at it. Just look. Poppy. It's my dog, y'all. Poppy Blanco TV. What's going on? Poppy. Y'all follow Poppy Blanco TV. Y'all go over there and follow him. Poppy. Hey, Poppy, we got to do a joint show too, man. I got something for you. We got to do a joint live. Now, look at this. I don't care about what this statute says, what it protects. I am not a consumer. Take that away. I don't think like a consumer. I am not unsophisticated. I'm very you ain't gonna pull that wool over my eyes. This standard is designed to protect consumers of below average sophistication or intelligence without having the standard tied to the very last rung of the sophisticated ladder. Look, it's designed to protect consumers of below average sophistication or intelligence. What is it saying? When they see an FDCPA claim, they automatically think you are unsophisticated and unintelligent. You are unsophisticated consumer. Is that how you see yourself? Is that how you see yourself? Do you see yourself as unsophisticated and unintelligent? Is that how you see yourself? That's what you are? You're unsophisticated and you're unintelligent? Wow. So what do you think? Oh my gosh, it gets even more. The standard protects the uninformed or naive consumer. What? So you mean to tell me if I bring an FDCPA claim, that's you see the box that you got to jump into? Yet also contains an objective element of reasonableness to protect debt collectors from liability for peculiar interpretations of collection letters. See, this is the other side of the FDCPA claim. Basically, what it's saying is many people who bring these claims have misinterpretations of the statute. That's what, and I see these teachers online posting a debt collection letter that clearly says what it says, but they tell their audience that it means something else. What is up with these deep esoteric interpretations of the normal, simple, everyday meanings of this stuff in life? What's up with this deep esoteric, like third eye, the pyramid type interpretation? Like, come on, man. Come on. Noting that the unsophisticated consumer test prevents liability for bizarre or idiosyncratic interpretations of collection notice. That is what I mean. The deep esoteric meanings, meaning it clearly says what it says, but they'll tell their audience, oh no, this is what it means. It literally says what it says, but they're saying, no, it means this. This is what they mean. We do not apply the unsophisticated consumer standard to communications sent to a consumer's attorney. You see what level that you really have to operate from for them to respect you when they see a FDCPA claim, unsophisticated, unintelligent. In addition to these general prohibitions, the FDCPA sets forth several specific examples of it prohibited actions. For example, 1692E prohibits any false representation of the character, amount, or legal status of any debt. Section 1692E5 prohibits threats to take any actions that cannot legally be taken or that is not intended to be taken. Basically, trying to scare you in the pan. 1692F prohibits the collection of any amount, including interest, fees, charged, or expense incidental to the principal obligation, unless such amount is expressly authorized by the agreement creating the debt or permitted by law. And 6092GA imposes on debt collector a duty to include certain content in initial communication with the debtor or any follow-up writing within 5 days. These general requirements in mind, we turn to the parties' arguments. You remember Big Papi? The parties agreed that when the original creditor charges off a debt, the additional contractual interest no longer accrues. That's a fact. Haney asserts a theory of implicit waiver to argue that the original creditor's choice to charge off a debt and cease collections of contractual interest also serves as a binding waiver of any future ability to collect statutory interest. To support his theory, Haney details the purported accounting consequences of a charge-off and cites the legal effect of a charge-off on a creditor's ongoing obligation to provide periodic statements. All right, let's go back here. The specific content includes the amount of the debt, the name of the creditor to whom the debt is owed, a statement that unless a consumer within that's it. Yeah, we all know that. Y'all read the FDCPA, 1692 GA. Y'all already know what it is. Haney appears to argue that because the act of charging off a debt is not merely a unilateral act, but an act that alters the parties' relationship and requires the original creditor to make representations to taxing authorities. They always tell you, for some reason, they always want to throw a totally separate branch of the government into their consumer obligations. Remit, mortgage, oh, it's a tax issue. Auto, oh, it's a tax issue. It's a tax. If y'all stop listening, listen. Who spearheaded that argument? That was one of them Gene Keaton type motherfuckers. We should view a charge-off as a complete waiver of any right to all forms of interest. The defendants argue the act of charging off a debt does not preclude the collection of statutory prejudgment interest because the act of charging off a debt does not eliminate either the original creditor's statutory rights or the debtor's ongoing obligation to pay the charge-off balance, a liquidated sum to the creditor. Remember that I said a few moments ago? Consumers look at the charge off this. The corporations look at the charge off like this. The corporations don't view the charge off the way the consumer views the charge off. And this is why when you only see things from a consumer standpoint, you can't interpret it from a corporate standpoint. So you got to take your consumer understanding and try to interpret what the corporate standard is from a consumer mindset. It never works that way. And many people online state that just they say this, that if they charge it off, you don't owe anymore. Or they think that getting a 1099-C means your process worked. A 1099-C means that they attempted to collect the debt, the collect is non-collectible, and they've given up the fact that they're not going to get payment from you. So they will send you a 1099-C. That's pretty much stating that we've forgiven this from remain in debt for you. We're not going to collect it. You're not going to pay. The IRS treats that as income to you. Now you must take that 1099-C and file it on your tax returns as other income. You have to put that on Schedule 1 now. And depending on if you were insolvent or not at the time of the charge off or at the time you received the 1099-C determines whether you'll have to pay taxes on that amount. What explanation did I just give that would give anyone any hint that their process worked? What explanation did I give that will give anyone any inkling that their process worked? It didn't. So everybody that's running around with a 1099-C, posting it on their social media page like they did their big one, actually just means you ain't pay your bill. And none of your processes worked that you were sending to them, and they got tired of responding to you. So they just sent you a 1099-C. That's what it means. But you'll have these young, still wet behind the ear teachers posting their 1099-C like the discharge process worked. Like you could get some money back out of it. The defendants acknowledge the unilateral act carries with it several legal consequences as provided pursuant to federal tax law and Regulation Z. They argue. C. McDonald versus Asset Acceptance LLC. Instead of amassing interest on a worthless account, the creditor sought to sell the accounts and shift the risk of non-payment to a third party for a nominal fee. This practice also permitted the creditors to remove the account from the financial records and receive a bad tax deduction. That's all it's for. It's called a worthless debt. And yes, you can get a tax write-off when someone owes your business and it didn't pay and you charge it off. It's a tax. It's pretty much a tax. It's a tax deduction. That amount can be used to limit your taxes for the business. The amount which has become worthless, like I just said, worthless debt, shall be allowed as a deduction under section 166A. Told y'all. And I ain't even looked down when I saw it. I told y'all. That's all it means. However, the unilateral act does not vest in the debtor a right to have the original creditor and its assignees otherwise forbear from exercising statutory rights to prejudgment interest. Here, there is no suggestion the original creditors expressly waived any right to statutory prejudgment interest. Similarly, there is no suggestion that they asserted an entitlement to statutory prejudgment interest. A failure to assert an entitlement to such interest, however, is not in and of itself proof of waiver. Rather, pursuant to Missouri law, implicit waivers must be unequivocally clear. If a waiver is implied from conduct, the conduct must be so consistent with an indicative of an intention to relinquish the particular right, and so clear and unequivocal that no other reasonable explanation of the conduct is possible. See, do you think Mr. Haney researched what his argument was? No, because they never do. In the absence of some express statement or unequivocally clear overt act, we do not presume waiver. Although we have never addressed the effect of a debt charge-off upon the availability of statutory prejudgment interest, several other courts have, including several district or courts applying Missouri law. Based on the analysis from these several courts, we conclude Missouri statutory prejudgment interest remains available following the charge-off of a credit card debt. So everybody that's showing these charge-offs, you sure they still not suing them in court? Oh, yes, they are, but they just won't tell you. Haney relies primarily upon a case involving Kentucky law, in which the Sixth Circuit held that the act of charging off a debt precluded future accrual or collection of statutory prejudgment interest as well as contractual interest. You're in the Eighth Circuit, though. In reaching this decision, the Sixth Circuit examined Kentucky's usury statute, which allows a default of rate of interest of 8%, but permits party to contract for a different rate. The court, deciding an issue of first impression under Kentucky law, concluded that the statutory rate of interest falls away entirely at the time the parties contract for a different rate. As such, if one of the contracting parties later waives its right to contractual interest, there exists a void of authority to support an award of prejudgment interest rather than a default statutory rate. A party's right to collect statutory interest is extinguished, superseded by her right to collect an interest rate she has specified by contract. Yeah, I mean, that's normal. In the present case, the district court relied upon the lower court ruling from the Eastern District of Kentucky that the Sixth Circuit reversed in Stratton. Haney notes this fact to argue that the Sixth Circuit opinion in Stratton undercuts the lower court ruling in the present case and requires that we reverse. Bro. So you trying to say the higher court disagreed with the lower court. You agree with the lower court, so the higher court is wrong. I get it now. I get it. First, the relevant Missouri statute at issue in the present case is materially distinguishable from the Kentucky statute at issue in Stratton. The Missouri statute merely states that the statutory rate of 9% is available when no other rate is agreed upon. It does not state that the 9% rate otherwise become unavailable if a party contracts for a higher rate, but subsequently waives that higher rate. Although it may be reasonable to conclude that such interest falls away and becomes unavailable if parties contract for a higher rate, such a reading is by no means compelled. In contrast, the relevant Kentucky statute examined in Stratton speaks in strict terms regarding the unavailability of statutory interest when parties contract for a higher rate. Second, we examined the federal statutory rights and privileges gained or lost due to charging off a debt. We find nothing inconsistent with the creditor or its assignee seeking statutory prejudgment interest after the amount owed is reduced to a liquidation sum through charge off. See, this right here, liquidated sum. And you're going to understand what that means from an internal standpoint. The tax benefit of a debt charge off, current realization of expense deduction or capital loss is a matter of concern between the creditor and the relevant taxing authority. Remember, they always want to bring another branch of the government into their consumer. They always want to bring some executive branch into the judicial branch. They want to bring the legislative branch into the judicial branch. They always want to, separation of powers don't exist to them. Haney appears to assert that any attempt to collect statutory interest is inconsistent with the accounting treatment of the debt at charge off. Even if Haney is correct that seeking statutory interest will be contrary to prior tax treatment, the consequences of such an act are a matter of concern between the creditor and the taxing authority, rather between the creditor and the debtor. You notice how these debtors always want to play the IRS when it's beneficial to them. They always want to play Congress. They always want to play the president. They always want to play a regulatory agency. Don't they know? They always want to play some form of a regulatory agency. A creditor's potential liability for penalties or additional taxes does nothing to change the liquidated sum the debtor owes the creditor at the time of charge-off, and it's highly unlikely a debtor would know of any communications between a creditor and the taxing authority or any ongoing changes or adjustments to a creditor's treatment of a reported item. Remember, when I said in the mortgage, In order for you to really have a void assignment argument, you would have to know that the investors voided the assignment, but the lenders still chose to foreclose. How would you have that information? They don't even disclose who the investors are. And you're not a party to the agreement. So what investor do you know that would give you that information? So that means your REMIC late assignment, voided judgments, voided assignment into the trust fund to help you get out of a mortgage is null and void because it has nothing to do with you and your debt. They can assign it to Mary Poppins. Has nothing to do with you. I know we want to think that it does because when we're in these vulnerable situations, we're grasping at straws. I understand. I get it. Holding taxpayer was allowed to retroactively increase a claim bad debt deduction in amount necessary to account for a charge-off. As such, it is difficult to appreciate how arguable inconsistency between collection efforts and tax treatment might aid Haney's waiver argument. But here's the thing. This is when they mean unsophisticated and unintelligent consumers because they know professionals would have never made that argument. They probably would have got sanctioned. See, consumers, they'll entertain this crap because they have to. But real lawyers, they would never entertain this. And this is what I mean. Consumers who think like consumers make some of the most ideologic arguments ever known on the face of earth. I look at myself as a professional in court. I would never raise such claims. Haney also emphasized that the act of charging off a debt and sending a charge-off statement relieves the creditor of the obligation to send periodic statements complying with the disclosure requirements of TILA. TILA and its regulation, however, are concerned with adequately communicating contractual terms addressing interest and finance charges on consumer loans. They are not designed for the general communication of state law to consumers or to govern the state law treatment of general claims for liquidated sums. Once again, when you think like a consumer, you make these outlandish ideologic claims. This is what happens when you make FDCPA claims. You start to get the stretching and stretching and stretching and stretching. Professionals do not make these arguments. Professionals know better. I know better than to make these arguments. I would never, not at gunpoint, would I make an argument like this. As a matter of fact, the FDCPA will be an afterthought in my case. I would forgot to add it to the claims because it doesn't even matter. Now, the context of Regulation Z, remember the context, and the enabling statute suggests otherwise, as they regulate disclosures of interest and finance charges imposed by the consumer's loan agreement. The regulation is not targeted towards disclosure of the fixed rate of interest states routinely imposes on debt prior to judgment. Nothing inherent in the process of charging off a debt precludes a claim for statutory interest. In Missouri's prejudgment interest statutes does not expressly preclude statutory prejudgment interest following a waiver of contractual interest. And once again, let's get down to the nitty gritty. I mean, he tried. He tried. And this is Haney versus recovery portfolio assets. So and I got another one coming up. I just want y'all can look this case up. Boy, he had a lot of arguments. So We reverse the judgment of the district court dismissing Haney's claims against Gamici in count 2 and 4 based on the attempted collection of statutory prejudgment interest on accrued contractual interest. We affirm the judgment of the district court on all other respects. So pretty much from Gamici, they allowed them to go back and redo it, but all the other claims, he's stuck in the water. He's stuck in the water with those. But let me show you. I got one more to bring you up. You ever heard of the term "show me the note"? You ever heard that term? Show me the note. Show me the note. You ever heard that? If y'all haven't heard of that, I'm about to get you very familiar. I'm about to get you very familiar with those cases. The show me the note. All right. So let me pull it up. Well, ink signature, show me the. I had to pull it up, but it's in my files. I don't. It's not the one. Yeah, just park right there until I get the case pulled up. Now, where is he at? Now, before we get to this, I want y'all to see. Before we get to this, I want. Oh, it's in my phone. I'll pull it up from my phone. Because I went over in TikTok the other night and it was actually very good. I don't know why people still do this show me the note. Is it because now do they really think that that's going to do anything, or do y'all think it's just you got to do
Don't
something?
miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
All right. Let's go. Let's get to it. All right. Thor Power Tool Co-verse. There we go. Now, this is the commissioner of the Internal Revenue, right? And this is Thor Power Tool. All right. Now we're going to get down. It's too short of a read. That's too short. That's too short of a read. See if we have it right here. All right, so basically the principle in this case was GAAP accounting methods do not determine legal liability. The Supreme Court ruled that even if something is acceptable under accounting standards, it does not control legal outcomes. Generally, accepted accounting principles are not controlling for legal determinations. Now, this other one, in this other case, well,
Bro, actually, I wasn't going to show this case, but I'll show it for what the hell. I'll do it. I'll do it. What the hell? I'll do it. What the hell? All right. In this case, the debtors Howard Richard Veal and Sheila Aisha Veal executed promissory note in August 2006 in favor of GSF Mortgage Corporation and a mortgage securing the note on real property located in Springfield, Illinois. On June 29, 2009, the Veals filed Chapter 13 petition and listed American Home Mortgage Servicing, Inc. on Schedule D as a secured creditor for the indebtedness, the Veal loan. 8. AMC filed a secure proof of claim on July 18, 2009, stated that it filed on behalf of Wells Fargo Bank as Wells Fargo's servicing agent. The proof of claim includes copy of the note showing an endorsement from GSF to option 1. The mortgage, a recorded assignment of the mortgage from GSF to option 1, Mortgage Corporation, and a May 15, 2008 letter from AMC's Jordan D. Dorchuk stated MC acquired option 1's mortgage servicing business. On October 21st, 2009, Wells Fargo filed a motion for relief from the automatic stay to permit foreclosure. The motion included 3 exhibits: the mortgage and itemization of post-petition amounts due and copies of the Veal schedules, but did not include authenticated evidence showing possession of the note or a transfer of the note to Wells Fargo. On October 5, 2009, the Veals objected to MC's proof of claim and responded to Wells Fargo's stay motion, arguing lack of standing, that MC's Wells Fargo were not persons entitled to enforce the note under the UCC. At the preliminary hearings and 2 notice of supplemental exhibits filed by Wells Fargo's copy of the note and assignments, not authenticated, the bankruptcy court on February 3rd, 2010, overruled the claim objection and granted Wells Fargo relief from stay, finding the documents presented adequately reflected Wells Fargo's standing and treatment the mortgage assignments as sufficient. The bankruptcy court made no specific findings addressing MC's agency relation with Wells Fargo or either party's status as a person entitled to enforce the note. The Veals timely appealed both orders to the bankruptcy appellate panel. Whether Wells Fargo has standing as a real party in interest to seek relief from automatic stay, whether it had a property interest or was a person entitled to enforce or otherwise had ownership or enforcement rights in the note, securing the mortgage. Pretty good questions. They've already missed one key element. But, of course, why wouldn't they? Everybody else does. Why would they be any different? Everybody else misses those core arguments. Why would they be any different? Whether AMC has standing as a real party of interest to file and prosecute the proof of claims, specifically whether MC was a person entitled to enforce a negotiable promissory note or an authorized agent of such under applicable versions of the UCC. Veal's arguments, neither Wells Fargo or MC established that they had any interest in the note or any right to be paid on the note. Consequently, they lack prudential standing and are not treated as real parties in interest. MC needed to demonstrate that it was authorized to act as Wells Fargo's servicing agent and that either MC or Wells Fargo qualified as the holder of the note under the UCC. The exhibits did not establish the facts. The Dirk Chuck letter attached to the proof of claim
was inadmissible hearsay and was never authenticated or offered under penalty of perjury. All right. Because the bankruptcy court did not make required factual findings on who was the person entitled to enforce the note or whether MC was the agent of such person, the claim allowance order cannot stand. Wells Fargo arguments. MC filed a proof of claim as Wells Fargo's servicing agent. MC asserted that status on the claim form by attaching the Dietrich's letter. MC relied on the debts listed in the VIL schedules and plan. Wells Fargo contended that the assignments of the mortgage to GSF to option 1 assignment and the option 1 Sand Canyon to Wells Fargo assignment supported the colorable claim to the property, and that possession or endorsement of the note was not necessary to obtain preliminary relief from the state. MC argued that VIL schedules and plain listing MC as the second secure creditor, could stop or waive the standing objective and invoke Rule 3001F to assert that its proof of claim is prima facie evidence of the claim's validity, shifting the burden of production to the VILs. Remember, court, you make an argument. All right, what you gotta say? All right, what you gotta say? All right, what you gotta say? What you gotta say? What you gotta say? All right, pleadings are closed. Let's see what we have here. The best man wins. Now, they cited a lot. Now, let's get to the right here. Standing framework. The court reaffirmed that both Constitution and producer standards must be met. Constitutionally, both Wells Fargo and MC met the requirements, injury in fact, causation, redressability, insofar as the automatic stay and claim allowance procedures affected their asserted rights. Prudential standing, however, requires a party to assert its own legal rights. Real party interest doctrine. The court emphasized that the real party interest analysis in the operative formulation of the prudential standing inquiry for these matters, a litigant must demonstrate that it holds the right to seek, enforce, or qualifies under recognized exceptions. An agent, an assignee for collection, or other recognized status that permits suit in one's own name. Now, here's the thing. What a lot of people don't understand is a lot of these agreements are not public. So you run the risk. Of making those arguments. You're going to run the risk of you may run into a brick wall. If you're going to make those arguments, you better make sure that they don't have it. Don't jump out there. Do not jump out there and you don't know if they got agency to recover on their behalf. Don't jump out there. You better know. You better know. Do not jump out there on a guess. The court explained that Article 3 negotiable instruments governs who is the person entitled to enforce a negotiable note, the party to whom the maker must pay to discharge obligations. Article 3 recognized several ways to be person entitled to enforce: holder, possession plus payee endorsement or bearer status, non-holder in possession who has rights of a holder, e.g., when delivery, transfers, enforcement rights through formal negotiation did not occur, or by showing, in rare circumstances, inability to obtain possession, lost, stolen. And it's called a lost note affidavit. And for some reasons, I agree with everybody. Those lost note affidavits be a little shaky now. The lost note affidavits, hold on now. The court stressed that ownership of the note and the identity of the person entitled to enforce it are distinct concepts. Both inform the real party and interest inquiry. Because relief from stay is a summary proceeding of limited effect, The BAP explained its prior articulation that a movement seeking stay relief need only show a colorable claim to enforce a right against a state's property. The only reason why they're getting the stay lifted, because even though that becomes property of the bankruptcy's estate, let me tell you this, and this is one of the clear evidence you hear from me. A security interest is more powerful than ownership. A security interest in something is more powerful than ownership. Because if you violate the terms of the agreement, they can exercise their security interest and they can take possession of the property and sell it to recover on the debt. So a security interest is more powerful than ownership. Now, but color claim does not. All right. But the panel clarified that this colorable claim standard does not relieve a movement of its prudential standing burden. The movement must still demonstrate a colorable claim as a real party in interest, that it has some colorable right to enforce the secure obligations, which may be shown by being a person entitled to enforce the note or by possession of ownership or other cognizable property interest in the note. Ladies and gentlemen, we're going to get into that bifurcation too. That bifurcation. You can't split it up. Yes, you can. Yes, they can. Today they can. That old 1800s, 1900s case about bifurcation, y'all could just waive it. Y'all could wait. You can put it right there. I know you, once again, I know your belief system don't want to do it, but you flush it right down the toilet. That's where it goes today. All right. We're going to get to that next. Just flush it down, take it out your mind and flush it down the toilet. Because that bifurcation argument, that's exactly where it belongs today. It belongs in the toilet. Because the mortgage follows the note. If I assign my note, okay, let's say I got security interest in this property. I assigned the note to Ali. The mere fact that I signed the note, the mortgage already follows. This is why they only record the mortgage and not the note. They don't have to record the note too. You notice how they never record the note, just the mortgage or the deed of trust? That's it. The mortgage follows the note. If anybody is a bifurcation, they can't split it. They're in the ancient Stone Age time with these arguments. I'm talking about how courts work today. Now, the panel examined Wells Fargo submissions and found that they did not establish that Wells Fargo was a holder, a person entitled to enforce or otherwise had an ownership interest in the note. The exhibits Wells Fargo relied upon: mortgage, post-petition, arrears statements, assignment of the mortgage, and copies of the note and assignment filed later as supplemental exhibits, did not prove Wells Fargo's statutory status under Article 3 or 9. Crucially, the assignment from Option Well did not contain language transferring the note, and no endorsement from Option 1 to Wells Fargo appeared on the note. Under Illinois law, which governed mortgage enforcement and common law principles, the court emphasized assignment of a mortgage without assignment of the underlying debt can render the mortgage unenforceable by the assignee. Because Wells Fargo failed to show any evidentiary connection to the note sufficient to demonstrate that it was a person entitled to enforce or had an ownership interest, the panel concluded that, boy, these people be calling me. I get calls from people all day. The panel concluded the bankruptcy court applied an incorrect legal principle by treating the mortgage assignment alone as dispositive and concluding Wells Fargo had standing. The panel therefore reversed the relief stay order. Now, are we getting somewhere? Remember, y'all, this is 2006. They don't make these mistakes today. No, they don't make these mistakes today. The panel explained that a proof of claim that will be finally adjudicated in a bankruptcy claim allowance process requires a showing that the claimant is the creditor or the creditor's authorized agent, a person entitled to enforce the note, or the agent of such person. because claim allowance has preclusive and final effect. AMC asserted it filed on behalf of Wells Fargo as the servicer, which they're all going to make those type of claims as a servicer. You better not come in. You better not step in the ring with me talking about you the servicer. You're going to get scalped on that alone. Because MC asserted it filed on behalf of Wells Fargo as servicer, but presented no admissible evidence, no authenticated dirt chuck declaration or other proof demonstrated MC's authorization by Wells Fargo or that either entity qualified as a person to enforce under Arizona's adoption of the UCC. Y'all remember when I posted on TikTok saying the UCC is state law? Notice how they did Arizona, a law applied to the note. Notice how they use statutory law. So when people talk about the UCC as common law, they're talking about the general UCC. That's not law. Like this is not the law. Oh, one second. I don't want to get off it. This is not the law. Hold on. Let me show you what I'm talking about. This is not the law right here. Everybody looks this up. This is not the law. This is not the law. I know everybody goes here. This is not the law. So, look, you got negotiable instruments. This is not the law. Let me give you an example of the law. Let me give you an example of the law. Let me give you an example. 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 Now, we just dealing with negotiable instruments, right? We just saw negotiable instruments. That's not the law. That's not the law. This is the law. This is the law. This is the law. For my state. This is the law. This is not the law. This is the law. This is statutory law because it's been enacted by the state legislature. This is statutory law. The UCC is statutory law. When people talk about UCC as common law, they're talking about this. This is not even law. This is just a guideline. Our collection aims to show each section of the UCC in the version which is most widely adopted by states. That means we will not always display the most current revision if that revision has not achieved widespread adoption among American legislators, meaning the Uniform Commercial Code is statutory law, not common law. But once again, this is kind of a matter of you ain't already know that. You just not figuring that out. That's how common it is. The bankruptcy court made no findings on these central contested issues. I told y'all, man. I told you some of this stuff. What's up, boy? What's up, Dan? Yes, that's always a good thing. At least pay all your bills until you're in a position to legally justify why you're not paying. Now, that's what I did. I paid my car. I paid it. I gave him what, $692 a month. I just gave it to him. Until I said, you know what? You ain't getting another goddamn dime. You want the rest of your money? You're gonna meet me in the middle of the ring in federal court. And at that, y'all know the rest is history after that. The bankruptcy court made no findings on these central contested issues. Given the lack of findings in the paucity of admissionable evidence, the BAP concluded that the record did not support the bankruptcy court overruling Ville's claimed objections. And the court must vacate and remand for further proceedings, including potential evidentiary hearing, so the bankruptcy court can determine the factual predicates necessary to resolve standing in real party and interest status. Now, the court stressed the bankruptcies Oh, let's get to the good part. The panel issued 2 related holdings as to the stay relief, the bankruptcy court's order granting as to the stay relief appeal. The bankruptcy's court order granting Wells Fargo relief from the automatic stay is reversed because the record did not establish Wells Fargo was a person entitled to enforce the note or otherwise had an ownership interest in the note sufficient to make colorable claim against the property. As a proof of claim appeal, the bankruptcy court order overruling Ville's objection to AMC's proof of claim is vacated and the matter is remanded for further proceedings because the bankruptcy court made no findings and the record does not establish AMC's standing. Now, after this case, right? Now here you go right here. Here's the case. Facts. The Villes did not dispute that in August 2006, Shelley Ville executed a promissory note in favor of GSF Mortgage. To secure her payment obligation of the note, Ms. Ville also executed a mortgage in favor of GSF covering certain real property located in Springfield, Illinois. So you already know that we went over the proof of claims. I know how that went. All right. We already know that Wells Fargo, that was reverse, right? Now we already know automatic stay. Okay. Now, the Villes challenged Wells Fargo standing to receive relief from stay. I think we already went over it in the beginning up there. Yeah, I think we went over it. I think we went over it. If there's anything that y'all want to go over in this, but I think we went over it. Ownership, interest, and promissory notes. I think we went over it. Yeah. So in this case, they actually got relief. They got relief from the they got relief, and then when they went back to court at the end, y'all know how it is. They actually did end up losing down the long run because I got the case after this, so they end up losing in the long run because if they were current, or I mean they're in bankruptcy, so it's kind of hard to be current, but they end up losing in the long run to Wells Fargo. But if it was a good one, they end up losing though. They end up losing that in that bankruptcy, so they end up taking the house. Yeah, they end up losing. So it is what it is. But oh nah. This is for you remix fellas. You hottie. This is for you remix. The note it's a void assignment. The note is a void assignment. You note, you void assignment mortgage people. Let's go. You mortgage people out of what is it? The mortgage is late. The mortgage, hold on, what they say? They violated the remix terms in the accounting terms, so the mortgage is the mortgage is void. Remember that? Remember that? Well, bring y'all tag everybody that you know. Share this with everybody that you know online right now that's making that argument. Let's bring them all. Let's bring them all to the congregation. Come on, y'all. Let's go get them. Go get them right quick. Y'all go share this. Go share this. Go share this. Let's all get up here at the same time. Watch this. Watch this. Another piece. Get him in here. Where they at? Where these gurus at? Ali, go get them. I want these mortgage gurus to get up in here right now. I want these mortgage gurus, please. Please. Please, y'all. All right. Please, y'all, go get them gurus because they still online. They still on Facebook. We know they not going we know that they not gonna show up. We know they not gonna show up. But you know what? It doesn't matter. So what we gonna do is we are going to continue with it. I was hoping they'd show up so they can make their arguments, but y'all know how that goes. Yeah, I know. I think they yeah. Okay. YHUDAI. We finally pulled the case up. Let's pull it up. It's in my phone files, y'all. So it's pulling it up now. Everybody that's talking about a mortgage and fighting the mortgage and fighting the mortgage. I'm just trying to see where they was. I'm just trying to see where they at. Got a weird name. No, it's not Hyundai, you doofies. God damn, Goof Troop. All right. I know what I'm gonna have to do. Yeah, I'm gonna have to get it off my phone because I don't know why. Yep, I'm gonna have to do it like this. I'm gonna have to do it like this. So I'm going to airdrop this to my phone. 1 second. Boop. There we go. And then I'm going to open on Google Chrome. And that's all it takes. So, mortgage people, where the mortgage people at? Where the mortgage people at? Nobody want to show up to they don't mind teaching. They don't mind teaching it. They don't mind telling you that your mortgage, they don't mind telling you that your mortgage is the remake transfer, the assignment is late assignment, it's over with. They don't mind telling you that, but they damn sure have a problem defending it. All right, there we go. They don't mind telling you that the assignment is late.
You're rocking with the best. You're rocking with the best.
all mortgages are fraudulent. Former owners will have recourse to sue for fraudulent foreclosures. Spread this far and wide. The whole industry could completely collapse. Due to the recent ruling by the Supreme Court, MERS is not the title holder. Real party in interest of any property and never was. All mortgages, past and present, are therefore fraudulent. This has devastating repercussions for all the loan industry, not just the MERS, because there is no longer a chain of title. People who have or people had mortgages, right, or are being foreclosed on or have been foreclosed on have an out, right? These people are now able to win in court and are having their mortgages settled and are keeping their homes, for the banks fear losing far more in class action suits. Now California is getting in on the action and suing MERS for filing false recordings with the county records, right? Recorders in every county in the state.
So, do you know you have 3 days to cancel that mortgage and they have to return their. So, I'm going to go over 15 USC 1635, where it's. So, do you know you have 3 days to cancel that mortgage and they have to return everything?
So, do you know you have 3 days to cancel that mortgage and they have to return everything? So, I'm going to go over 15 USC 1635, where it talks about the right of rescission as to. So, do you know you have 3 days to cancel that mortgage and they have to return everything? So, I'm going to go over 15 USC 1635, where it talks about the right of rescission as to certain transactions, right? Did you know that you can cancel your mortgage in 3 days and the bank have to return everything? It's not a scam, it's literally federal law. Okay. 15 USC 1635. Okay, and we're going to break it down. So what that does, it gives powers to the borrower, right, to cancel certain loans, mostly refinances, home equity line of credits, or any type of second mortgages within 3 business days of signing. It's like a 3-day federal advisory remorse rule. And if the lender does not give you proper disclosures, you may get up to 3 years to cancel. Okay. So let me break it down real simple. So if you take out a loan that uses your home as collateral, you have the right to cancel within 3 business days. No question asked. Okay. Okay. But the lender must tell you this clearly and give you the forms to do it. And here's what the laws say, right? So I'm going to read from 15 USC 1635, right of rescission. The creditor shall clearly and conspicuously disclose in accordance with regulations of the Bureau. Okay. So the creditor shall clearly and conspicuously disclose to any obligor the rights of the obligor and provide forms for rescission. Okay. So they must give you the notice to right to cancel, 2 copies, one for you and one for the lender, and the truth in lending disclosure. A lot of times they don't give it. Guys, look at if you're going to purchase a home. This is very important, okay? So your rescission right is extended up to 3.
Did you know that robo-signing is illegal? There was a case not too long ago where a woman actually I don't know, inferiority complex language. I mean, I never have a problem when somebody says things to me. I don't think that they're trying to be superior in most regards. I don't think they're trying to be superior in any way, shape, or form. And none of these conditions were met. There was no invitation. This is what I'm reading from the notice that I gave my client to send to the sheriff. Okay. None of these conditions were met. There was no invitation. The deputy was not acting as a delivery carrier. No emergency exists in the field of law itself. And you subscribe to each one of these little things. And the other thing is people think they're going to get a fair, it's going to be fair. It's going to be fair. It's not going to be fair. It's not going to be fair anywhere. I know your secret. Okay, guys, I was just on my live and they suspended it because I was telling you a story about what happened to me. And for some reason, they thought that I was saying something about doing something to someone else. So in case you were wondering,
let me explain why a lot of foreclosure cases get dismissed when even the bank messed up. It's because of damages. In court, they hurt me is not enough. Judges need numbers. If you can't show money loss, they act like nothing happened. So saying something like they caused me stress and problems will get dismissed. What survives is something like this. Because they ignored my request, they charged me $450 in late fees, $1,200 in legal costs, and $300 in inspection fees. Those are real damages. Here's where to find them: your mortgage statements, your payment history, your bank records, your foreclosure notices. Look for late fees, property inspection fees, forced insurance, attorney's fees, escrow shortages, and add them up. Put the total in your complaint, and judges don't have to guess. Did you know that robo
Shit. Ain't that a bitch? Ain't that a bitch? Okay. Like Hadi, the plaintiff alleged that purported assignment of his note in deed of trust to the investment trust was ineffective because the assignment was made after the closing date. Ain't that what they arguing online? To determine whether there was a legal basis for concluding that the trustee's attempt to accept the loan after the closing date would be void as an act in contravention of the trust document. The Court of Appeals looked to a New York statute which provides if the trust is expressed in an instrument creating the estate of the trustee, every sale, conveyance, or other act of the trustee in contravention of the trust is void. In applying this statute, the court relied on a then recent decision by a New York trial court, Wells Fargo Bank versus Bobo. They be running around today loving Bobo, Bobo, which involved a mortgage that had been transferred to an investment trust after the closing date. The Bobo 1 court stated that the acceptance of the note and mortgage by the trustee after the date the trust closed would be void. Oh, shit. I may be wrong, y'all. I may be wrong. Oh, shit. Well, let's continue to read. Based on Bobo 1 and a bankruptcy decision that followed Bobo 1, Galaski concluded that plaintiff's factual allegations regarding the post-closing date attempts to transfer this deed into the trust, into the investment trust, are sufficient to state a basis for concluding the attempted transfers were void. Damn. Uh-oh. Well, let's just keep reading. After Galaski was decided, a New York Intermediate Appellate Court reversed Bobo 1. In rejecting the trial court's view of New York law, the higher court explained that the borrower in that case, as a mortgagor whose loan is owned by a trust, does not have standing to challenge the mortgage assignee's possession or status as assignee of the note and mortgage based on purported non-compliance with certain provisions of the trust.
You're rocking with the best.
Why does it keep muting me? I'm going to do this shit all night till I get it right. And opposite, it keeps muting me. How about now? Hello, hello. It keeps muting me. Hold on. Right here. Okay. All right. I think we good. Let me see. Hello, hello. Okay, I hope we good. In opposition to the demurrer, Udai relied on Galaski to support his assertion that the 2009 assignment is void. In Galaski, plaintiff's loan was pooled with other loans and transferred into an investment trust formed under New York law. Like Udai, the plaintiff alleged that a purported assignment of his note in deed of trust to the investment trust was ineffective because what? The assignment was made after the trust closing date. Please tell me if that's what they do online today or not. Somebody just put a 1 in the chat because I don't know. I don't know what I'm talking about. I have no clue on mortgages. Like Udai, whatever the hell his name is, plaintiff alleged that a purported assignment of his note in deed of trust to the investment trust was ineffective because the assignment was made after the trust closing date. To determine whether there was a legal basis for concluding that the trustee's attempts to accept a loan after the closing date will be void as an act of contravention of the trust document, the Court of Appeals looked to a New York statute which provides, if the trust is expressed in an instrument creating the estate of the trustee, every sale, conveyance, or other act of the trustee in contravention of the trust is void. In applying this statute, the court relied on a then recent decision by a New York trial court, Wells Fargo versus Irabobo 1. So when they would say, oh, Irabobo says it, you don't know what you're talking about. Irabobo says it. I said, have you read Irabobo 2? Crickets, 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 crickets. Nope. See, they responded with that, but that's it. Did you read Irabobo 2? No response. Oh, of course. Of course it's not going to be a response. Based on Irabobo 1 in a bankruptcy court decision that followed Irabobo 1, Galaski concluded that plaintiffs' factual allegations regarding the post-closing date attempts to transfer his deed of trust into the investment trust are sufficient to state a basis for concluding the attempted transfers were void. After Galaski was decided, a New York Intermediate Appellate Court reversed Irabobo 1. In rejecting the trial court's view of the New York law, the higher court explained that the borrower in that case, as a mortgagor whose loan is owned by a trust, does not have standing to challenge the mortgage assignee's possession or status as an assignee of the note and mortgage based on purported noncompliance with certain provisions of the trust PSA. The trustee of the investment trust in that case was thus entitled to summary judgment on his action to foreclose the mortgage. Subsequent cases have consistently rejected Irabobo 1. Irabobo 2, Ferguson versus Bank of New York Corporation. Based on Irabobo 2, the court construed New York law such that violation of a PSA will render challenge assignment of a deed of trust at most voidable but not void. Rajaman versus Deutsche Bank. Under New York law, unauthorized acts of a trustee of an investment trust were not void but voidable. Butler versus Deutsche Bank. Even before Irabobo 2, the vast majority of courts to consider issues have rejected Irabobo 1's reasoning, determining that the acts of a trustee in contravention of a trust may be ratified and thus are voidable. Salvador, the bankruptcy court case Galaski cited, has received similar negative treatment. Bezerra versus Deutsche Bank, Kufas versus U.S. Bank, in reference Stanworth. The rejection of Irabobo 2 is based on sound reasoning. Under New York law, unauthorized acts by trustees may generally be approved or ratified by the trust beneficiaries. Under Irabobo 1, however, a stranger to the trust would have standing to assert that the unauthorized transaction is void, thereby giving the stranger the power to interfere with the beneficiary's right of ratification. A stranger's right under Irabobo 1 to declare transaction void would thus conflict directly with the beneficiary's right to ratify the transactions. This conflict is voided by rejecting Irabobo 1. This conflict because a trust beneficiary under New York law retains the authority to ratify trustees' ultra vires act, such as a late transfer. The act must not be void, but merely voidable, because the decision upon which Galaski relied for its understanding of New York law has not only been reversed, but soundly and overwhelmingly rejected. We decline to follow Galaski on this point. So all you social media gurus talking Galaski, you don't know jack shit and couldn't tell your a hole from your ass through a hole in the ground or sink a hole on a bloody, muddy day. You idiots.
You're rocking with the best.
The social media gurus are idiots. You're low IQ.
You're rocking with the best.
You're dumb. You're low IQ. No intelligence. No wherewithal. No court maneuvering. No understanding. You're low IQ trying to teach people. You gurus are low IQs. You don't have the mind power to deal with this stuff. You don't have the experience to deal with this. You don't have the level of understanding it takes. You're stupid. That's what you are. Y'all stupid, dumb, retarded. UDI offers no other authority for his contention. No other authority for his contention. Based on the authority cited above, indicate a post-closing assignment of a loan to an investment trust that violates the terms of the trust renders the assignment voidable, not void under New York law. One example of stupid, I'll give you one right here. I'll give you an example of stupid. I will give you an example of stupid. I'll give you an example of idiot. I'll give you one right here. You want one? Here you go.
I'm going to just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
And boy, oh boy, no wonder you haven't reached back out to me when I sent you this case right here. And this is out of California. And this California case cited cases from all over the world who's saying the same thing. And this is the appellate court decision in California. And you say you're helping your clients with their mortgage in California under this jurisdiction. And that's your argument, that the assignment was late in REMIC tax laws. Remember, I told you they always want to add other branches of the government into a court case. Now they want to add tax law to a court case. Even if they violate it, it doesn't matter. They'll just pay the fines. They'll pay the taxes to the IRS and keep it pushing. Want to know why the courts will never render this a late assignment void? Because it's not its job to do so. If the IRS says if you assign mortgages that are late after the cutoff date, then you're going to pay taxes on the trust level income. The IRS didn't void the transaction, so the court is not voiding the transaction. When Congress changes the law, then the courts will void the transaction. Until Congress says no mortgage will be considered a mortgage if it's after 90 days, it's voided. Nope, you don't have it in a trust. You better not have it there. That's when the courts will follow suit. But Congress set the tone on this, and we have separation of powers, and the judicial branch will never interfere with the legislative branch unless it's the Supreme Court, and the Supreme Court won't even take this case because it's already settled. See what I'm saying? REMIC late assignments. Well, here go your late assignment right here. Based on the authorities cited above, indicate a post-closing assignment of a loan to an investment trust that violates the terms of the trust renders the assignment voidable, not void. And right here, because the decision upon which Galaski relied on for its understanding of New York law has not only been reversed, but soundly and overwhelmingly rejected, we decline to follow Galaski on this point. And everybody's online citing Galaski. You're in for a rude awakening. You are in for a rude awakening, stepping into court without, they're waiting on that argument. The opposing attorneys are going to chew their asses up. Woo! The reversal or irrevocable one in the judicial response to it occurred after Yahadi filed his second amended complaint in its opposition to the murmur. Udai now contends that New York law is irrelevant and has no role in this case. He points to a choice of law in the deed of trust. Even if this clause governed the question whether the assignment is void, Udai offered no citation of federal or California authority other than Galaski to support his assertion that the 2009 assignment is void because it was made after the ISA's trust closing date. We therefore reject it because you will never find the case after Galaski that's going to agree with it. Every case after Galaski has been reversed and rejected. All those 2008 to 2011 securitization arguments are dead. I told y'all the window was short and they deaded it. You would never get through the door that way ever again. From 2008 to 2011, everybody was winning on those arguments. Right when 2012-13 hit, I started to see a lot of reversals. Soon as 2014 hit, it was over. 12 years ago, you gurus are 12 years. I told you, they're always decades behind me. They're always decades behind me.
You're rocking with the best.
I do this in real life. I do this in real life. I do this in real life. Not fake life, real life. Now this is in response to one of my clients' mortgages. Hey, what do they say? Comes now plaintiff. Hold on, what they say? Right here. On December, the assignment of a mortgage from blank to blank was recorded within the Cook County Recorder of Deeds. Plaintiff is filing a motion to substitute plaintiff contemporaneously with the instant motions. A response to the defendant's motion cannot be filed until an order substituting the plaintiff has been entered. As such, the servicer will need additional time to file the appropriate response to the defendant's motion to dismiss. Wherefore, we respectfully request this honorable court enters an order granting a motion for extension of time and granting the plaintiff an additional 14 days to respond to the defendant's motion to dismiss. We can't respond right now. Please help us, judge. We need you to substitute us. Get us out of here. Let them deal with it. We need more time, please. Can we substitute parties, please, in mid-stroke of the case? Oh, can we get an extension? You'll never see a summary judgment pop up on me. We do this in real life.
You're rocking with the best. You're rocking with the best.
I try to get these gurus up here. These gurus ain't want to show up for it because they knew what was going to happen. When a new culture comes around, you better be ironclad with what you're saying because I'm going to dismantle your argument in 2.5 seconds. Accounting is strictly regulatory and investor related. And this is why, I warn people by strictly trying to use accounting as a legal defense. Because when you use accounting as a legal defense without understanding its true functions and how it's measured and its mechanisms, you will run into major issues when trying to assert your accounting defense. As a matter of fact, an accounting should never be used as a legal defense. And when we get to the court section of you're going to understand why all this is going to tie together. You will understand why I'm saying do not use accounting as a legal defense.
You have to understand how they see it, how they operate. Once we understand how they operate, you'll realize that in many cases, the debt that they're already trying to collect from you is a debt that they already. A lot of the balances, look at your contracts, they remain in balance. It's never what's actually booked. Ever looked on TILA, page 2 of your contract? You ever notice that the itemization, that number is always low, and then when you get to the finance charge, it's always a bigger number? Isn't the finance charge supposed to be disclosed? The items of the finance charge supposed to be disclosed on TILA? But you know it's on page 2 or whatever the page, your itemization. It's always some amounts paid to others on your behalf. It's always a low number. But then you look back at your finance charge, when you subtract that low number from the finance charge, you be like, well, where the rest of this money at?
Breaking off another hot explosive mix.
They studying the source now. Supreme Elite.
You're rocking with the best.
Came on reading numbers, they were reading memes. He was reading fire, planning out the dream. Turn every late fee in the case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress in the last
rocking with the best.
How you turn the loss in the last check.
Gotcha, bitch.
Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print.
You're rocking with the DJ that keeps the hits coming.
He designed the way we move our 2 cents. Whipping up, he got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, I can't glance. You look like you wanna let go straight. I thought so, okay. I'm back in this symphony, stuck on the band. What's up?
We're about to take it back.
Gotcha, bitch.
You're rocking with the best.
Put a 30 to the semi and shoot it. Put a stand on the Glock and just use it. It's gonna be a headshot, we aim at your medulla. I got on my jewelry on, so I ain't tryna be a brawler. So we gon' shoot like a hooper. Hop in the car, put it in turbo mode.
You're rocking with the DJ that keeps the hits coming.
I might just kill the club. Hop in the car, put it in turbo mode. I might do 200, I might do the whole dash. I might just crash it with, when I have to pay for it. I might just kill the club. Put it in turbo mode, I might do 200, I might do the whole dash, I might just crash it with, might have to pay for it, I might just kill the club, hop in the car, put it in turbo mode, I might do 200, I might do the whole dash, I might just crash it with, might have to pay for it, I might just kill the club. I'm on the stage, I'm lit, it's turned up, they see my ice, I'm lit, I do it all the time, all my life on the line, shorty be acting real shy, she wanna show me, she wanna slide, hop in the back of the ride, they look at my eyes, it's demon time, like, do you wanna ride with me?
Gotcha, bitch.
Are you down to die for me? Are you down to die for me? Do you wanna ride with me? Shorty, you mine.
You're rocking with the best.
Gotcha, bitch. Come for a ride. Hop in the back of the ride. Hop in the girl, you dead. Girl, you thick. Hit you from the deep. She ain't got a man. Baby, you can leave. Damn. Baby, you can leave. Damn. Girl, you dead. Girl, you thick. Hit you from the deep. She ain't got a man. Baby, you can leave. Damn. Baby, you can leave. Damn. Girl, you dead. Girl, you thick. Hit you from the deep. She ain't got a man. Baby, you can leave. Damn. Baby, you can leave.
This is the new culture hip hop. You are rock with the Supreme Elite University.
For credit acceptance with the case, the lawsuit, I called him up after we settled, just to let him know when I got the title, and I've been texting him because I'm trying to get him to be a part of the professional team. I actually have like real live professionals in these fields that got extensive years of professional that I'm in cahoots with.
Mr. Gamble, how you doing, sir? Hey, nice talking to you. I just wanted to let you know personally, I appreciate your help with the matter of resolving this with credit acceptance. I did receive the title. Just wanted to give you a thank you, man. I appreciate your hard work, man.
I'm glad we were working out.
Yes.
And, you were a big part of the process too. So.
Yeah.
I never heard of that.
Promissory note. The note you signed for your mortgage. What do they call it?
Oh, seems like from the orders that I've seen, it's still called a note that's not supposed to be bifurcated from the deed. It's still called those things.
There you go, right there, bro. We're on two different levels, bro. I'm gonna tell you that right now.
But if I was to get into the mindset of criminals,
because you came up here like lightweight trying to check me on my credentials, and you don't even know it from a professional level. See, this is the difference between me and you. This is the difference between me and you. I know things you don't even know exist.
I'm answering with procedural language instead of banker's language that I spoke about earlier.
Internally, if you live in that world, you know all of them do it. This is the difference.
If I was to speak on...
Let me tell you this, hold on. I'll let you get the mic back. This is the difference in how you will argue and the way I will argue. Because the name, what they do, the new name it takes on, the new ways they move around, that all plays a role in a consumer claim. Knowing the game from their field. And this is why I really don't like doing these things, because everybody I come across, they act like they know it all, but when it gets to the top level, professional level, they have no clue of that realm. I operate from that realm. I don't operate from TikTok consumer level consumer claims. I operate from a corporate professional realm, bro. In real life. Real life. Real life. So, respectfully, bro, there's nothing more for me and you to talk about. You don't even know that answer. I really don't even want to talk to you about anything else no more. I'm respectfully, bro. There's really nothing for us to talk about no more. You don't come on my channel trying to G-check me, and you don't know what I know. Don't try to G-check me. You're supposed to know the answer.
According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."